First, I want to introduce my colleagues here on the stage. First, furthest from me is my law partner, Steve Brodie, who is also a member of our art law group at Herrick and is head of our banking practice and specializes in art loans, where art is pledged as collateral in obtaining loans from various financial institutions and similar institutions. But finally, and clearly the woman of the hour today, is Judith Pearson, president and co-founder of ARIS Art Title Insurance Company, which is essentially the major source of art title insurance in the world today. And we will be discussing the topic today: what is art title insurance, and should you get it? I should start by saying that although our art law practice at Herrick has since expanded to include all manner of transactional and litigation matters involving art, when we started almost 40 years ago, and for many years thereafter, and really continuing to this day, we've had a substantial practice involving the recovery of stolen art, including artworks looted by the Nazis during and before World War II, and art stolen in less dramatic ways from warehouses and the like. And most often, we brought these cases against so-called good faith purchasers. That is, individual collectors, galleries, and museums who were literally left holding the bag and the artworks because they acquired them without knowledge that they had been stolen. And under the American system of property law, an original owner of stolen artworks never loses good title to such works and has the right to recover them from a good faith purchaser without any requirement that the current possessor be compensated in any way for his or her losses once he is ordered by the court to return the artworks to the original owner. And throughout this long period when we were litigating these claims, we regularly were met with one question from many of the players in the art world, and especially from journalists and commentators who wrote about our cases. And the question was a very simple one. Why in the world didn't those that acquired these artworks buy insurance to protect them against later claims that they did not have good title to the art? And both to compensate them for their losses and to handle any litigations that might arise. And the simple answer to this simple question was very plain and very frustrating. There simply was no art title insurance available with respect to the purchases of artworks. You got it when you bought a house, you couldn't get it when you bought a valuable or any piece of artwork. Then about 7 years ago, Judy Pearson and her partner Larry Schindel established a company that may substantially change the way we do business in the art market. They started ARIS, Art Title Insurance Company, and began to offer insurance to collectors and others to insure against claims of faulty title and similar claims with respect to art transactions. And what I will do today is have a conversation with Judith and Steve to help you learn more about art title insurance and to explore whether and when collectors and others like you in the audience should be considering the purchase of such insurance, perhaps as routinely as when you buy a house. But although the title of our topic today starts with what is art title insurance, I'd like to ask Steve first to address in a general way the second part of the topic, namely, should you get it? And specifically, to start us off, Steve, perhaps you can give us examples of situations in the art market which come up much more often than we all like to admit, where terrible consequences for collectors and others have resulted that perhaps could have been avoided if someone in the picture had purchased art title insurance. Steve?
Thank you, Howard. Before I start to tell a couple of specific stories, doesn't sound like it's right. I think I should mention a few things that are common in the art business, and I think many of the people here will understand this, and it makes for title problems. One of them is the common, what's called handshake culture. It is the art business, different from other areas of commerce today, still to some significant extent, lives on very sparse documentation. And that makes for certain difficulties when you start to talk about title issues and over long periods of time. Another feature which stands out is the common practice of people acting as agents for undisclosed principals. Again, if you think in terms of establishing title and questions being asked that can go back many decades in some cases, particularly some of these theft cases that Howard was referring to, it's too complicated a subject to address here, but it is sufficient, I think, to say that the statutes of limitations for these kinds of claims are very, very long. And therefore, some of the issues concerning chains of title and problems that may have resulted from thefts can go back very, very far. Having said that, let me mention a few other specific cases and specific kinds of things so you get a sense of the types of problems that can develop and do develop in the art world. One of them was a case involving, this wasn't art, but it's the same legal principle involved. This involved Yankees pitcher Don Larson, who pitched the only perfect game in World Series history against the Dodgers in 1956. He gave his uniform that he wore that day to the San Diego Hall of Champions, a museum in San Diego where he lived, in 1964. And then in 2012, he wanted it back. And the issue was, did he really give it? Was it a gift? He claimed he loaned it to them. There's no paperwork. Again, this goes to the handshake culture I'm talking about. And ultimately, the museum gave it back to him because they couldn't prove that it hadn't been, they couldn't prove that it had actually been a loan to them, a gift to them. Another case involving a different kind of a problem involved the son of the great photographer Ansel Adams, who had given 6 original prints to the Fresno Metropolitan Museum in 1983. The museum eventually went out of business, and it was seeking to sell those prints to raise money to pay its creditors, not unlike, in some respects, not unlike the Detroit situation some of you may be familiar with today. And so the issue arose as to whether or not the terms of that gift, I don't think there was any question but that it was a gift, but it was not easily proven, or it wasn't, I don't actually know how the case ended, but it was not, certainly wasn't cut and dried as to whether or not the terms of the gift permitted those prints to be sold under these circumstances. Another kind of thing that came up, that's come up over the years are the so-called resale clauses that are found in primary market sales, where it's either by a first sale by a dealer on behalf of an artist, or maybe on his own account, or by the artist directly to a purchaser. It's common enough practice to put into the terms of the bill of sale at the time of the primary market first sale that on a resale by the purchaser, at least during a certain period of time, there has to be a right of first offer back to the original seller or a right of first refusal. Suffice it to say, if you're not lawyers, those are terms basically mean you have to go back and offer an opportunity to purchase the work back one way or another. Let's see, I have too much time here. Should I go into the other stuff? Okay. There are a few other things that are worthy of some mention here. There's one case that was resolved by the New York State Court of Appeals a year or two ago that points out how difficult things can be. This case involved the boyfriend of the widow of the sculptor Jacques Lipchitz. And eventually the Court of Appeals decided that the widow had given him, had actually made a gift to him of a sculpture that she had gotten from Jacques Lipschitz himself. The evidence was that she had written, that she was giving it to him on the back of a photograph of the work. The problem was that her son, the widow's son, didn't actually know about this. He thought he had taken title to it through the will, and he had gone and sold it through Marlborough to a buyer who in good faith had purchased it. And basically everybody appeared to have been acting in good faith and innocently. It was just there wasn't sufficient information and there was no way of getting it. And the Court of Appeals eventually came down on the side of the boyfriends who in fact had sold it himself to somebody else at that point. But you're getting a picture of how difficult this can be where there's no public record of these kinds of things, and you have practices in this sphere that historically have provided for minimal documentation, and people often not acting in their own names. I've got some other examples, but I think that's enough for now.
Yeah, we can cover them later. So Judith, let's go back to the first part of the title of our topic today. And why don't you briefly explain just what we're talking about when we're talking about art title insurance? What does it cover, if anything, in addition to pure title claims? And who in the art market is it designed to protect?
So let's start back a little bit, going over some of these facts. So the art market is the largest lawful business out there, with the third amount of crime just behind guns and drugs. And as Steve has already said, a lot of these transactions transfer possession of works of art with little to no paperwork. And there are thousands of examples that we can go over as to where this has created problems. But the history of our product is, I come from an insurance background, and the other co-founder was a lawyer. And we started a business thinking that we could bring due diligence to the transactional basis, to the transactions for art, not so much the art historical perspective. And literally, as we were hanging up, I live in Denver, the shingle for the Denver office, one of our museum clients called up and said, hey, I'm advising a patron to buy a French Impressionist painting that was in Europe during World War II. No matter how much research we do, we can't close the provenance. Hey, lawyer, you insurance person, do you think you can solve this? Because the seller and the owner, two different people, are unwilling to indemnify if there's a claim. So we put our hats together, we created a solution for the one transaction, and we set off a journey that took 7 years to actually form our own insurance company to provide title insurance. But one of the things we learned in that journey is so much of what people talk about in the market is theft, whether it's historical theft, like Nazi looting, Russian Revolution, Cuban Revolution, or contemporary theft, where the FBI would suggest $6 billion worth of art is stolen annually. Well, we found that that's only about 25% of the claims. Really, 75% of the claims are more traditional liens and encumbrances. So what does that mean? It means documentation has been lacking. Somebody didn't have the authority to sell. Somebody didn't pay either their estate taxes or income taxes. Maybe they borrowed using the items as collateral for loans. Maybe they didn't have authority because it was a family relationship. So we see estate issues, we see divorce issues. That's where the claims come in. And when you do traditional provenance research to determine what's the value of the work of art, how important is the work of art, where has it been, the provenance is really a subset of title. Ownership is the whole picture that you think about when you have a car, when you have a house, when you have other things. So what is title insurance? It's really insuring the ownership. Just like real property title insurance, it's a one-time premium, life of ownership, including the legal heirs. The limit of liability is the value of the work of art at the time of purchase. If it increases in value over time, you can apply to increase the limit. And then it covers the value of the painting plus defense costs. So if a claim comes in and we think it's defendable and we lose, we pay the defense cost plus the value of the work of art. couple of points that I want to make is, while we all talk in terms of art, this is all tangible personal property. Many art collectors also collect cars or wine, jewelry, memorabilia. We were talking earlier about the sports memorabilia. So anything that is a secondary market is something that we can write the title insurance for.
And do you write insurance for artworks that are located outside the United States on occasion?
We do. We write coverage worldwide, and so there's no limitation for that.
Okay. So I'm going to ask Judith and Steve some questions that I hope reflect some of what's going through your minds about our title insurance. And then we're going to leave some time for questions from all of you toward the end of our talk today. So my first question is, here we are at Art Basel, and many in the audience, of course, and many more outside this room, have been considering purchasing mostly contemporary art, perhaps by living artists. They did their due diligence, and they've traced the artworks back to its original creation, and even its first sale. They're dealing with a highly reputable gallery who has a nice, shiny, big space here at Art Basel. So my question is, why in the world would a person in that situation have to consider buying our title insurance? Isn't it just another unnecessary expense, along with commissions and other things that they have to pay as part of the transaction, when they're virtually certain that there's absolutely no problem with this artwork?
Let me respond to that first. I don't think there's any doubt, but that common sense would suggest that the probabilities are better that your title is good under the circumstances Howard outlined, but it doesn't eliminate some of the risk. And it's the same thing you can do when you purchase your house. If you hire a lawyer or anybody at all familiar with real property records, it's pretty easy to get a pretty good idea of what the title looks like and whether there's any particular concerns. You don't have to go to much trouble to do it without buying insurance, and yet pretty much anybody would think you were making a bad mistake if you bought a home without buying title insurance. It's a sensible thing to do for a reasonable cost, given the risk having to do with the value of the asset. Now, if I'm buying something here that costs $5,000, maybe I'm not going to do it. But if you start to get up to a certain price point, and I'm certainly not going to say what that is, I think it just becomes common sense for this to become convention, and that people buy it, and they don't have to think about it. It just eliminates something that can be eliminated, that would be a nightmare if it turned into a problem.
So I'm going to start with secondary market, but we'll keep it to artists that are alive. And the cases I'm going to talk about are all things that are in the public record. So I'm not here to pick on any one gallery, but it's just more interesting when you have a case that you can talk about. So let's start with one of the best, Gagosian Galleries, and he's here today. Nobody can argue that Gagosian's one of the best primary art dealers out there. There was an article in the Wall Street Journal many months ago about how they're worldwide. They've got $1 billion of sales. They represent some of the most important artists out there. So here's a story, a guy named Charles Coles, who in his own right is also a best of the best. He was a curator at the Seattle Art Museum. He was a dealer for 30 years, and he was also publisher of Art Forum magazine. He knows what he's doing. So he calls up Larry Gagosian one day and says, hey, I've got a Mark Tansey painting, who, by the way, Mark Tansey's still alive, still painting, still represented by the Gagosian Gallery. He goes, can you sell this painting for me? And he said, and it hung at the Metropolitan Museum of Art for a while. And they said, of course, that's a great painting. I remember it hanging at the Gagosian Gallery. I think we can sell that for you. Will you sign a warranty of title for me? He said, of course I'll sign a warranty of title. And in the New York Times, when a claim came up that I'm going to describe in a minute, he said, he was quoted when the New York Times said, well, didn't you sign a warranty of title? He goes, yeah, but I just wasn't thinking about all the issues. Here are the issues. As soon as the work sold into the UK, the Metropolitan Museum of Art raised their hand and said, we have a 31% gifted interest in that painting. In addition, Charles Coles does not own that, the rest of it. His mother, Jan, does. So I was on my way to New York to give a presentation. I thought, well, this is an interesting case. I think I'm going to go on the internet and see what I can find out about the ownership of this painting. And up pops the gifted interest in the painting. So I thought, well, kind of an jaded insurance professional. I don't think the Met would do this, but maybe they just put this information up there because of the litigation. So I sent one of my art researchers out for all the Martianzi books that we could find, and every single book post-1994 had the information of the gifted interest of the Metropolitan Museum, as well as that Jan Coles owned it. So do I think these are bad people? No. What I really think is going on is that the art market just doesn't think in terms of transactional standards like you do in every other business purchase. There's lots of stories on the best of the best, and of course there's Noldor. Does everybody know what happened with Noldor about 2 years ago? Essentially, for those in the audience who do not know, if there was a gallery who represented American art with the most stellar reputation for 165 years, that was Noldor. And about 2 years ago, they evaporated overnight over litigation of selling faked and forged works because of a dealer that nobody had heard of before selling some amazing modern works. So people say, well, how can you have helped in that situation? And the answer is, we may not have been able to figure out any better whether they are faked or forged works, but we certainly wouldn't have written the product or the policy unless we got the information about who Resale is. So one last point on the primary market. There was a lot of discussion about fakes and forgeries and can you chase the title back all the way through. And since we know that there's always unknowable information, in our entire book of business, we only have 3 works of art that we can take back definitively to the artist. If you are buying a primary work from a primary gallery or from the artist itself, because there's very little likelihood of there being a title dispute, why wouldn't you start the chain of title as it exits the studio so that when these issues when you're selling it in the secondary market, there is no question that chain of title is unbroken.
Thanks. Okay, so whether the works are contemporary or not, I think it's fair to say that it's now become the norm in the art world for any prospective purchaser, certainly of any substantial piece of art, to check the growing number of extensive databases that have now been established to see whether the work has been listed as having been stolen. There's Art Loss Register, which of course has a information booth here at Art Basel. In Germany, there's lostart.de, and even the FBI and Interpol have databases that are available to the public, and new databases are being established even as we speak. And we've all been schooled in the art market to not make a move in terms of purchasing art without checking these databases. In addition, if a substantial purchase is being considered, some collectors will hire consultants who will do extensive due diligence to make sure that any gaps in provenance can be easily explained, or that there really is no problem lurking with respect to the history of an artwork, even one that may go back a few hundred years. Some will hire researchers to conduct due diligence to make sure that there are no problems. And often this research will reveal that somewhere along the chain, an auction house, a reputable auction house, Sotheby's or Christie's, was involved. And certainly one may assume that that auction house did due diligence at the time that the work was consigned to them, and therefore that would also be some insurance, as it were, that there's no problem with the provenance. So after spending all this time and effort, and sometimes a fair amount of money, to ensure that what you're getting is safe, again, why have another level of expense? What are you adding to the picture to all this extensive diligence that these experts have put to use when advising collectors on a prospective purchase?
So I'll also take that one in two parts. Part one is, if you research all these databases, why aren't we clear? Well, I've already talked about the fact that really most of the claims come from traditional liens and encumbrances opposed to theft, but these databases aren't foolproof either. So the best example of that one, maybe some of you heard a few years ago, where Steven Spielberg bought a painting from a very reputable gallery, that the gallery, before she sold it to Spielberg, checked, it was just when the Art Loss Register was getting started, so she checked the FBI. And the FBI sent back, no worries, we don't have any record of this being stolen. And as the FBI started staffing up some 12 years later, they started sending out cold case reports. And one of Spielberg's assistants noticed that his beloved Rockwell was on that list. And this was pure and simply a mistake. Everybody tried to do the right things, but mistakes happen. So, first of all, only 25% of the claims. Second of all, mistakes can happen. As far as the researchers go and all the art due diligence that can be done, there's always unknowable information. Again, those gaps may be small or those gaps may be big. There was an article just yesterday where there was a Rothco that had built into the transaction with the private sale dealer that said you can never reveal our name as having sold this work of art. And we don't want our name revealed for two reasons. One was we don't want anybody to understand the finances, and two, the work hangs in the Dallas Art Museum, we had always thought we would gift it to them, and we don't want any embarrassment. The deal goes through fine, they sell it to a private buyer, and then they want to sell it again. And it goes into an auction catalog, and the auction house recognizes that it had been sitting in the art museum, and all the information came through. So that happened to be one where, unfortunately for the seller, that they were revealed, but we can all guarantee you that there's all sorts of secret statements that are behind all the transactions, creating the unknowable information. Steve?
I think actually what Howard said to start the question almost answers itself. The fact that there is a growing practice, which makes a lot of sense considering the prices that are being paid for certain works of art, where people will hire consultants and spend considerable amounts of money and certainly check these databases that are becoming into common usage. It all speaks to the fact that people are looking for some kind of assurance. And I think without knowing it, because they're not oriented this way, what they're really looking for is insurance. They're looking for an insurance company to come in that can assess, that's in the business of investigating this and assessing risks and managing risks and putting a price on it. That's what they do. And they can do it better than the consultants and the researchers and people checking databases who are experienced at doing that. This is what you're really, this is what an insurance company is for. And I think that all of that behavior that indicates that people are concerned about these things is speaking of what we're talking about.
Let's go to the other extreme for a minute. So someone is considering the purchase of a very substantial piece of art. He or she has had research conducted, and lo and behold, there are a few problems in the provenance. Not only gaps, but maybe some questions about proper import into the United States from other countries and other similar issues. Does that person then say to themselves, you know, no problem. I now see why there's this wonderful thing called art title insurance, and I won't have any worry in the world Do you insure works as to which there may be some serious problems?
Well, I'll start with we don't insure the burning building. So we have had people call us and say, I'm in the middle of a title claim, what can you do? And the answer is probably not much there. However, our business is really built around getting a submission in, doing as much research as we can, identifying the gaps, and then making a risk assessment over those gaps. So depending on what those gaps look like, we can often either figure out a way to manage through it, or we charge a premium to it. And let me give you a really good example. One example that we had, we got a call from a client, and I hate using World War II examples because this product really is not about World War II, but it's a great example. So we got this call from an estate attorney who's selling the last major item in an estate. And they call us up and they're like, so, there's no records on this work of art, and the last remaining heir that's alive kind of sort of remembers this work of art going on the wall in 1947 in South America. Do you think you can do anything? And we all laughed for a minute, and then we said, well, obviously you're calling us because you think that there is something we should be able to do it. So this one might take a little bit longer, might be a little bit more expensive than the norm. However, let us see what we can do. And lo and behold, we found that it had been stolen during World War I. We had good information that the heirs of the people who it was stolen from might not bring a claim. So we were actually able to do what a title company does for real property and clear this one defect by getting affidavits signed. We never found out what happened during World War II, but we figured that that made it defendable. And so we were able to write the policy, and everybody was able to sell it, and the buyer was able to feel better about making that purchase.
You know, let me add the experience we had earlier this year, because I think it's relevant here. I was representing a private bank in New York, making a substantial art loan to it was an entity that was owned by various family members, and it settled an estate. And there was a huge collection that was being put up as collateral here. And the paperwork that was presented to the bank, and then the bank actually ultimately turned it over to Herrick to review, was pretty clear. I mean, you could always raise questions about it, but it looked as if the chain of title was pretty clear and looked authentic for some portions of this collection. But there were some other valuable works where there wasn't an obvious problem. We couldn't make hide nor hair of it. It was confusing. It was written in the kind of shorthand business record speak of New York art dealers in the 1960s and 70s. And so we had the thought that, well, maybe we'll bring in, we'll get some title insurance for this, which would turn that portion of the collection from unacceptable collateral into good collateral, and it would make the deal work at the size that the borrower needed it. And that's exactly what happened. ARIS went in, they looked at it, they said, yeah, we think we understand this sufficiently well to insure it for this price. The price under the circumstances was quite reasonable, and the deal went forward.
And I think that reflects the fact that it's not only upon the acquisition by a collector that one might consider purchasing our title insurance. But why don't we break for some questions, and if there's still time, we can continue the conversation. Does anybody have any questions?
Yes, and you may have already answered this. I'm sorry. My name is Gail Elston. Actually, I'm an art lawyer from New York. How do you price your insurance?
Generally, it's between 1 to 3% of the value of the work of art at the time that you purchase it. We have a minimum premium of $500, and certainly if something it is a lot riskier, it may be more, but that's a one-time premium for the life of ownership, including the heirs.
Okay, and is there any state regulations similar to real estate titles? I think, for example, the fees on real estate titles are state regulated. I was just curious.
No, it's not like that in New York. They're not filed rates that are fixed like that.
Okay, thank you.
you purchase insurance, and let's say a work of art's $1 million, and you buy the insurance in 2014, and 20 years later, the work is determined to be counterfeit and not authentic. Do you receive only the value of the price based on the cost basis, or are you getting the lost value as well? For example, if the work, if it were authentic, would be worth $20 million 20 years later, are you able to recover that lost opportunity cost?
If I understand the question that you're asking, if a work of art goes up in value, you should be getting appraisals at any rate every couple of years. So if there's a third-party appraisal, we're happy to receive a submission to increase the value of the work of art. And generally, it's at a fairly nominal fee because much of the work has been done before. But you have to keep your appraisals up to date.
Then there's a question about, he was referring to authenticity. You might want
Right.
to address
No,
that.
no, that doesn't answer the question. Let's say you pay whatever you paid
Right,
for the
right.
insurance. Okay, 20 years later, the work is not authentic.
Right.
But the value of similar works would be significantly greater. What do you recover as the owner of this insurance policy in 20 years?
We do not cover authenticity at this point. Authenticity is really a matter of opinion, not a matter of fact. However, provenance and title are kind of second cousins of each other. So we really recommend that people, if they're going to buy a work of art, go negotiate the price, find the work that you love, don't pay for it, and let us do the research. Because what we do know is 100% of the time, when it's a faked or forged work, it's a made-up provenance. That doesn't mean that there aren't certain circumstances where it has a good provenance, it still may be a matter of opinion, that can be challenging, or that we don't uncover something and it's still not authentic. But those are a lot rarer than the pure fakes and frauds that are out there. In addition, we actually just announced that we've put together a team of, we're looking at technology, tracking technology, as well as creating certain standards around authenticity. So we're hoping to solve that issue, but it's not solved at this time.
Is there any product on the market that will cover authenticity of
No.
works?
But just to follow up quickly, if the face value of the policy reflecting the appraised value of the artwork at the time of the purchase of the policy is, say, $10 million, and then at the time of the loss, it's discovered that it's not authentic, and therefore the true value is, zero or much less than that. Would you still pay the face value of the policy on the loss?
If the loss is a result of authenticity, we do not cover it.
But let's say the loss is a result of theft, but it then discovered that the true value.
That becomes pretty fact-driven.
I remember law school exams.
Submit the loss. We'll decide how we're going to settle that one. That's a little more challenging, and that's fairly rare.
I hope so.
Any other? Yeah.
I want to go back. My name is Roland Chantal. I'm with Canvas. We're an online art repository. You said something in the early part of the conversation that discussed creating standards. Those standards don't exist presently. So new emerging artists that are creating authentic works of art that are giving the roofers back to the sellers and what have you. What standards are you proposing that would permit both your title as well as any real property insurance to exist? And that's the first part of the question. The second part of the question is when you take a look at primarily false conveyances, double conveyances that have occurred in the marketplace that may have been either illegal or by theft or by war or what have you, what ways do you have to backtrack and cover a collector from the standpoint that if your firm, as she basically asked before, that the state, a state body would basically regulate an insurance company, if your firm were to ever dissolve, let's say 20 years from now, people pay these premiums, is there a follow-on insurance or reinsurance company that takes on that responsibility for the work that you've done for the past 20 years?
So 3 years ago, we were acquired by a publicly traded A-rated company called Argo, and they back our paper. So as far as, we're as good as anybody out there because we're backed by an A-rated company called Argo Group. The first part of your question is that's exactly what we do, is we do as much research that we can, and then we make a risk assessment based on what we see as the gaps, and then we will pay the claim that we decide to insure over. And it's almost backwards to real property title insurance. And I love this story if I have a few moments. There's a woman that I've been doing a lot of sponsorships with for years at different things. And we would talk about title insurance and what have you. She comes up to me one day. She's a valuation specialist, not a business valuation, not art valuator. And she comes up to me, she goes, I've been listening to you all of these years, but I finally understand what you're talking about. Let me tell you what happened. My grandmother owned a house, and when she died, she gave it to her brother. But her brother didn't change the title. Her brother just moved in, they continued to pay taxes, what have you, and when he died, he gave it to one of my cousins. And again, it's in rural whatever, and my cousin did the same thing. Didn't change title, didn't pay estate taxes, but they paid property taxes all the time. And lo and behold, when my cousin passed away, it was gifted to me. And I'm not moving back to rural whatever. So I wanted to sell it. And the title company would not let me sell it until I opened up all the estate taxes that went all the way back, paid the estate taxes, and then could rightfully have title to it. She goes, well, what do you guys do? And I'm like, we're just the opposite. Unfortunately, we can't clear those defects because, quite frankly, we don't know what all those defects are. So what happens is when a claim comes in, that's when we get to clear the defects. So that's what our premium is based on.
I think we have time for one more question.
I'm just curious, lately we've been hearing the works that are selling for 140 million, 150 million. How much research or no research do you suspect is being done by the people that are buying at the auction of Francis Bacon? And are they being insured?
I'll you answer that.
Yeah, well, let me start with that. Yeah. When we represent either buyers or sellers with respect to very high-end acquisitions, I think it's fair to say that a great deal of concern and hence research is done to assure that there are no problems. A great deal of time and concern is also spent in figuring out who's going to be responsible if something should go wrong, and warranties of title by the seller and other ways to provide some assurance that if something goes wrong, the purchaser can turn to someone else to make himself whole are also considered. But I have to say that we would be remiss in those situations, in the midst of these negotiations, if we did not do, which is what we do routinely now, and say, what about title insurance? The real question for you, since you're considering spending so much money on this, is not so much whether you should get it, but in our view, figuring out who should pay for the premium. Whether the seller, the buyer, or perhaps splitting it between them.
Let me add one thing to that, which because the reference there implies the involvement of an major auction house, and there is, I think, appropriately a certain amount of comfort that people take from the resources and the degree of scrutiny that I think one can fairly assume is put into works that are sold through major auction houses where they're putting their name to it. And in fact, the title does carry a warranty coming out of that sale too from the auction house. However, it's not long enough, and it's not the same thing as title insurance. It's comfort, it's not insurance.
And we just got the 2-minute warning, but I'd like to explain, has anybody here actually read the consignment agreements and the sale agreements from the auction houses? It's really important for you to recognize the first thing that happens is the consignor has to give an absolute warranty of title. Not that they don't know, that there's absolutely nothing wrong with it, rather than what we ask for, which is a knowledge-based warranty. That warranty gets passed on to the buyer. The auction houses have to give a warranty of title for a limited period of time, which Steve said, but how they manage that risk, because the auction house is not in a business of providing insurance. They are in the business of being an intermediary. They have what's called a rescission clause. So if the buyer is sued, the buyer goes back to the auction house, the buyer gets their sales proceeds, but the seller is then responsible for sales proceeds, buyer's commission, legal expenses, and marketing expenses. So it's pretty sad if you're an active collector, and it's really sad if it's an estate. And while we can talk very clearly about the auction house, similar agreements, they're just not as standardized, happen in the private sale world as well. So you have to be very careful about what you're signing.
And just to finish up, every breach of warranty, every promise along the lines of "I'll stand behind this sale if anything goes wrong," has a relatively short statute of limitations attached to it. The normal rule under the UCC, which is applicable in virtually every state except Louisiana, is 4 years from the time of sale, which is not a long time in light of the many incidents where that gallery, that seller who was solid and strong and had the financial backing, if anything should go wrong, suddenly is no longer around. And then even if they are around, the time has passed, and that's the end of it. You have no one to turn to. The auction houses usually add a year to that, but again, it's 5 years, and that's it. So it's a problem. So thank you very much for your attention and your participation. Thank you.